Everybody, welcome back. Welcome to the coolest place to be this summer, Ethicsverse Day 2.0. We've had two phenomenal sessions so far today, and this is one that you're not going to want to miss. We're breaking records left and right. We have 4,500 ethics, compliance, legal, and HR people sign up for this, virtual session that we're doing. We've had almost 28,000 emoji reactions, okay? Our first session was all about whistleblowers. We had some of the world's most famous whistleblowers talking about their experience. Our last session, we were diving deep on AI and how we can really manage this risk that's like erupting within our organization. And now we're going to be talking on this third session. This is our keynote for the day. It's called Presidential Appointees and DOJ Veterans on What Works. So as we get started, like I say, and every single day I say this to my kids even, your network is your net worth. Neither are big enough. So drop that LinkedIn URL in the chat and we're going to get started here. We have a couple of quick announcements. So connect with at least one person today. Connect with the folks on the panel. Connect with me. Definitely follow the Ethico LinkedIn page. There's always great clips coming out there. And I dropped into the chat also a link to the Ethico YouTube channel. So if you ever miss an episode, if you haven't been able to see all the episodes today, all those things live on there, along with our world famous, fastest growing ethics and compliance podcast in the world called The Ethics Experts. Okay, so of course, I don't even like making money around here. I just like giving away books. We got a phenomenal book giveaway happening in this session. We're going to be talking about three of my favorite books. Those are going to be passed out to those who are most active in the chat, who are asking the best questions, who are sharing the best perspective. So we're going to be giving out You Can Culture. This is a new book that Tobias just put out. We had him on the podcast recently. Phenomenal book. And then two of my favorites on influence. One is by Dr. Robert Cialdini called Influence. This is full of studies on influence, what really drives influence, and our job in ethics and compliance is to really change human behavior. Many times that's influencing our stakeholders on the front lines, and it also involves influencing our bosses. It involves influencing leadership to get the resources we need or to get the endorsements we need to really drive our program forward. So that book is phenomenal. And also, Influence is Your Superpower by the one and only Zoe Chance. She is a friend of the show. And so we're giving away 10 of those today. Can you believe it? As you're dropping your LinkedIn URLs in the chat and all that kind of stuff, I want to share the exclusive offer for this session. We have a new package called the DOJ Defense Package. So we have an exclusive Ethicsverse Day offer. 25% off if you book a demo today. Don't worry if you're not ready to make a move right now. It'll be a no pitch zone demo like we're famous for, but it's incumbent on you to see what's out there, and it's incumbent on you to have the right tools to make the biggest impact possible in your organization. So this DOJ Defense package is really all about getting the right risk intelligence on your, in front of the eyes of your team. This involves your hotline, case management system, flexible disclosure tool, remediation controls that are going to allow you to have a consistent application or a consistent remediation of whatever risks end up kind of making their way into your central risk brain, along with flexible risk assessments. So when we can iterate through our risk assessments a little bit faster, we can get better risk intelligence, and like I always say, make better bets with our time. So unlocking that compliance team impact, it does a lot. Showing targeted actions and improvement can help us rest easy at night, knowing that we're doing the right job and we're doing that job well, that we're building a program that would withstand outside scrutiny, that we'd be able to sort of make the case for steps forward in the effectiveness of our program. And we can really push the value forward for departments like ours, ethics and compliance, which are in many organizations viewed as cost centers, viewed as apart from the business instead of a part of the business. It's critical that we exhibit value quickly. So when we can get better intelligence, when we can be that true circulatory system of the organization and gather insights that we then can present to management, it reinforces our job. It helps to really frame out the impact that we can have. So up to 25% off. There is a reason that the G2 community has called Ethico the best ethics and compliance software in the world. So if you haven't checked it out, or you're thinking of making a change, or you feel like the love is lost, check out G2. It's full of verified reviews. And with all that, I want to touch on one other thing. Ethicsverse Day is like the best day of the year. This is like Christmas, okay? So we also have prize packs that we're giving out. So if you want to win one of these prize packs, which you get a hoodie, you get a really cool mug, and you get a couple of books sent directly to your door, definitely jump into this chat and keep it going. Man, I can print this chat out, ChatGPT, a book out of this chat. So the chat's been blowing up today, thousands and thousands and thousands of emojis. And with that, I'm going to pass it over to the coolest guy in compliance, Matt Kelly. How's it going? Let's get a round of applause for this panel. This is going to be a phenomenal keynote. How's it going, Matt?
It's going very well, Nick. Thank you for the introductions, and thank you for everybody who is either joining us for the first time this afternoon or thank you for sticking around after the previous sessions. We're happy to have you here. So this is our keynote session for the day that I have the honor of moderating. We are going to go for another, it is 90 minutes in total, so we're going to 4 p.m. Eastern. We are here to talk about the regulatory enforcement environment, how it has shifted quite a bit from Biden administration to Trump 2.0 administration. And while some parts of it are going to be very different in the feel of it for corporations, a lot of it is not. So we're here to talk about all of that. What's changed, what has stayed the same, what compliance teams will still need to be good at for a favorable resolution if you are in some sort of discussion with regulators, what new things you might need to be good at or to consider, and all that fun stuff. So we have a great panel. In addition to Nick floating around, we have 3 guest speakers, all of whom have lengthy Justice Department and regulator experience. First is Matthew Axelrod. He these days is a partner at the law firm of Gibson Dunn. He is the former Assistant Secretary for Export Control Enforcement and a former senior Justice Department official. Matthew Axelrod, welcome. Thank you for being here.
Thanks for having me.
Also joining us is Leigha Simonton. She is a partner at the law firm Dykema, and she is former U.S. Attorney for the Northern District of Texas, which is based in Dallas. Leigha, welcome.
Thank you.
And another friend of Leigha, a partner at Dykema, Scott Hogan, who is former First Assistant U.S. Attorney in Dallas and an expert on the False Claims Act, which I suspect we will talk about at length at some point here. But Scott, thank you for joining us as well.
Thank you. It's great to be here.
So I wanted to start by asking each of you, take a minute or two to give us your thoughts about what has changed. We are here in July 2025, and we are witnessing unprecedented change in the regulatory landscape. From your vantage point, what is keeping compliance officers awake now that maybe we did not have to consider 12 or 18 months ago? Let me start with Matt Axelrod, and then Leigha, and then Scott. What do you think is the new thing that people should be concerned about or keeping their eye on the ball?
Sure. Thanks, Matt, and thanks, Nick, and thanks to Ethico for having us today. I'd highlight 2 things. First, compliance officers now have the challenge of reminding their employees that the law is still the law and needs to be complied with. I know it's strange, but it's true. I can't tell you how many CCOs have told me that the business, having heard about things like a pause in FCPA enforcement, for example, come to them and ask whether they still have to worry about FCPA risk. In other words, can they go ahead and pay bribes? And the answer is no. And the explanation why that the compliance team gives usually has 3 parts. This may sound familiar to many of you on the call. 1, it's still illegal, and we don't do illegal things at our company. 2, there's a 5-year statute of limitations. This administration runs for 4 years, so there's still enforcement risk depending on what the next administration decides to do. And 3, there's a risk of enforcement by other agencies, both state agencies and then foreign enforcement agencies as well. So that's one thing. The need to remind everyone that we can't break the law. That's new. The second thing, and this is sort of my wheelhouse, so I may be a little biased, but is the rise of sanctions and export and controls enforcement. I think this was on the radar screen, a year ago when I was running export enforcement for the U.S. government. But I think it's now even higher on the risk priority charts. In this administration, we've seen other corporate enforcement areas. There's been a pullback or a deprioritization, but for sanctions and for export enforcement, because of that direct nexus to national security, it's been full steam ahead. The head of the criminal division, Matthew Galliotti, has identified sanctions as a priority enforcement area. The commerce leadership has promised a dramatic increase in enforcement for export controls. agencies like OFAC and BIS have announced multiple enforcement actions, including a recent $216 million penalty from OFAC. So those are the two things I'd highlight, Matt.
All right. And Leigha, what would your answer be to that same question?
I think Matt hit the nail on the head in terms of compliance officers worrying that their resources are going to be taken away and people are not going to listen to them or follow the law or their rules or their compliance program. And at the same time, I think they feel like a lot more has been shoved onto their plate because the priorities of this administration are different than the ones of the last administration in ways that affect them in terms of exactly what Matt said, tariffs, export controls. There's also immigration. If you have, the enhanced immigration enforcement, if you deal with people who are on any type of visa, that is a concern. Anyone who deals in Mexico has any types of factories or imports things from Mexico or has sort of an element having to do with Mexico with the cartel enforcement, that's important. So compliance officers, I think, are wondering what is on my plate, what's not on my plate. I think everyone thinks this is all on my plate. At the same time, they're worrying that their resources are going to be taken away. So it is a really difficult time to be a compliance officer right now. And
Scott, what would you say as well?
I think they both hit it pretty well. But one of the things that, to kind of sum it up, also is the lack of predictability. There is this, in the past, I think folks have kind of seen changes in priorities coming. They've been kind of telegraphed that this is what we're going to be doing. And the sands are shifting a little bit more, it seems, day to day. And I think that causes folks in the compliance world and the enforcement world to really be uneasy in what they're facing. I think also Leigha mentioned, kind of new priorities or going into new fields or new areas like that weren't enforced in the past, like DEI programs, the expansion of whistleblower protections and encouragement of whistleblowers across a number of areas anymore. And then also, and I'm sure we'll talk about this later, but a real expansion of the stated intention for FCA, False Claims Act enforcement. Yep. It provides, I think, a lot of stress for folks in the compliance world.
I have to say, just to put a news peg on this discussion, just yesterday I saw the Justice Department had a False Claims Act enforcement settlement for tariffs. And I've been writing about this stuff for more than 20 years, never had to write about it until yesterday. And, just another sign of there are new things coming that, I get it, that I'm sure there have been previous enforcement actions, but it's not something that I ever thought compliance officers would necessarily be sweating and talking about, and yet here it is. Let me ask the opposite question of all of you now, and then I'll include Nick, you as well at the end there, but what has not changed for compliance officers? Because I can remember there were a lot of cynical people in January who thought we're not going to have any enforcement. All the compliance people will be laid off by July. It's July. We all have a ton of stuff to do, but I don't see that, the mechanics of what you need for an effective compliance program. I don't think that's going to change. The importance of a CEO saying we don't break the law, I don't think that's going to change. So there seem to be some notes that are still constant here, but I'll go, I guess, maybe in the same order, Matt Axelrod and then Leigha and then Scott. Like, what do you see as these things are still going to endure? What endures?
Yeah, so I totally agree. The need for strong compliance programs has not gone away and is not going away. What's changed, and Leigha mentioned this, is it's the amount of ammunition that CCOs have to convince others in the C-suite of the need to invest in compliance. The reports of DOJ pulling back on corporate enforcement can sometimes make, compliance dollars a harder sell. But let me give you my take on why those dollars are still one of the best investments that a company can make. So from the perspective of mitigating enforcement risk, strong compliance programs are essential for two different reasons. First, one of the express factors that DOJ considers in deciding what resolution is appropriate in a corporate investigation is the existence and effectiveness of the company's pre-existing compliance program. So if your company ends up in the middle of a DOJ investigation, you're going to need to explain your program and why, despite the strength of that program, something may have happened that shouldn't have. And second, by having a strong compliance program, you lower the chances you'll ever be in the crosshairs of an investigation in the first place. So to me, like, none of that's changed. The DOJ guidance hasn't changed. Strength of your compliance program is a specific factor that you're going to have to justify if you're dealing with a DOJ investigation. And of course, you don't want to deal with a DOJ investigation, so having that strong compliance program can help reduce the risk of that happening in the first place.
Okay.
Yeah.
And Leigha and then Scott.
Yeah, just to build on that, there are several things that have not changed that compliance officers, I think, can use in discussions with others in their companies to ensure that they stay well resourced and supported. And those include what Matt said in terms of there are still the principles for evaluation of corporate compliance programs that is still active. I checked the criminal fraud section website just today, and it is still there. And in fact, some of those criteria are listed in terms of how a company will be treated if they self-disclose. So it's very important to have that strong corporate compliance program in terms of any DOJ interaction that they might have in the future. Also, it's important in terms of how they handle whistleblowers, because we have all of these whistleblower programs that are still there. And in fact, they're being expanded in terms of the antitrust whistleblower program, and there's additional crimes that can now be reported under the criminal whistleblower program. So they still have to worry about whistleblowers and making sure that they have the right mechanisms in place to be listening to their whistleblowers and making sure they're not retaliated against, and that they have the support of the company to mitigate any problems that are happening that are being reported so they don't go outside of the company. And the other thing I'm going to say is a business concern. It's always going to be important for compliance programs to be able to enforce their rules and regulations and have a culture of compliance that they can build on, because the thing that we saw the most in U.S. attorneys' offices, and I know Matt saw this in Main Justice too, is bad actors within a company, and they are stealing money. Every person on this podcast or this webcast right now who is listening, who's in a big company, you have someone in there who's stealing money. They're embezzling, they're doing something bad. The company doesn't want that. So your bottom line is hurting if you don't have a strong compliance program. And then there are also PR risks that come with problems that are not detected immediately. And it kind of flows from having perhaps a bad actor in your company. But if something leaks, either from a whistleblower or from something else, from an investigative journalist about some type of problem that's happening in your company, that's bad. No company wants that to happen. And a good and effective compliance program can mitigate that risk.
It's funny, Leigha, I will say that one thing that sticks with me here in Boston, where I am, last year, one of the large pharma companies, they had employees who were embezzling money. The employee was collaborating with her fiance, who set up a dummy consulting agreement. They had dummy invoices. They embezzled $4 million. They were eventually fined. They were fired. They were indicted. They were sentenced to prison. The marriage is off. But that was an FCPA violation in every single way except for the F. Mm-hmm. Other than that, that was unfolded just like an FCPA risk. So, tying it back to this is a business risk, and whether you, to a certain extent, it's almost immaterial to compliance officers. You still need these basic block and tackle capabilities. Scott, let me turn to you, and I would especially like you to talk about the importance of dealing with whistleblowers in Speak Up, because you are the False Claims Act person here, and it seems like we're going to use the False Claims Act for all sorts of stuff now. So whistleblowing is going to be an important jump ball for companies to try and take possession of.
It is. And one of the most critical aspects of whistleblowers, in my experience, is they want to be heard and they want to feel like action is taken, right? So there's so many relators, right? Whistleblowers turned False Claims Act whistleblowing filers feel like their concerns were ignored, that they had raised them, whether it's to their supervisor or to their upper leadership, and nothing happened or nothing changed. I don't believe that most folks who turn whistleblower ever want to be. They just want to do their jobs, do them well, and go home to their friends and family in a given day. But it's often when they feel like they are pushed to that point where their conscience doesn't allow them to keep going and keep stand by and watching this continue to happen with no action occurring on the company's part. So I think there's got to be, one, a quick response, right, to any concerns that are raised. Two, a intent in listening, right, that intentional listening that allows that person to feel like they've been heard. And then three, some type of circle back to the whistleblower with a reminder, or a lot of times you're going to be able to tell them exactly what you did or what action the company has taken. However, they see and hear things in their everyday work. And if they feel like that their concerns have been heard, questions have been asked, corrective actions where appropriate have been taken, I think that person that could ultimately end up a False Claims Act relator will likely never get there. Most whistleblowers, their primary motivation is not, I can get some large recovery from government funds that have been pursued under the False Claims Act. Like I said, they're there to do their jobs, go home to their families each and every day. I think it's only when they get to that point, or when they feel like they've been wronged by their employer through some type of HR discipline or whatever the case may be, that they end up going down that False Claims Act road.
Yeah, and then they can also be a returning customer, and they can spread that around to their friends at the lunch table or whatever, because to your point, everybody talks, everybody hears something. Or everybody hears what's going on, and there's so much risk intelligence in our organization. And we were saying this on an earlier session today, that we're really only scratching the surface on the level of engagement that we can have from all the stakeholders in our organization to mitigate these risks. And when I look at all these changes that have happened, I mean, this whole session started from the three of us, me, you, and Leigha, at the Compliance Week event, kind of talking about, the panic that was sort of in the air about these changes and is compliance going to get deleted? And while some of that may have died down, I don't feel like we all are sort of taking advantage of the opportunity that all this change is presenting. Whenever there's change, whenever there's things moving around, there's more opportunity for us to drive more influence forward. And we may have a leadership team that thinks, oh, great, bribery's back in play. Well, it's incumbent on us to make sure that their light bulb is screwed on and that light bulb is on so that they can see that all these changes are really presenting a lot more risks to the organization. And so when the waves start rocking, you need more people on the deck to kind of keep those sails in place, or the ship can capsize. And so now is the time for us to take advantage of all these changes. There's a lot more is the same than has gone away, I think.
I wanted to maybe take things a bit out of order here and talk a bit about some of the Justice Department's recent policy pronouncements. And in particular, they have focused a lot on the importance of voluntary self-disclosure. And at this point, if you voluntarily self-disclose and take a few of the other steps of cooperating with an investigation and whatnot, you're pretty much guaranteed a declination. But they keep emphasizing the importance of voluntary self-disclosure. I am still stuck on what's the analysis companies should do. Because on one hand, you could say, let's self-disclose. It's an easy win. We get the declination. On the other hand, they're not wrong to think, let's keep quiet. We'll clean up the mess, but they're probably never going to find out about it. They're all focused on other enforcement issues anyways. Let's not self-disclose. And I am torn between how do you figure out those variables. I'm curious if you could walk us through how people should evaluate that. And maybe I'll start with Matt, Axelrod, and Leigha and Scott, but what's the calculus that we're trying to figure out?
Yeah, look, I agree. I think it's one of the toughest strategic decisions, and it's always fact and circumstance dependent. There is no one size fits all answer because, as you pointed out, there are real concrete benefits from self-disclosure, but there's also risk. Even if you get that declination, which now DOJ has made more certain, there's still the headline. There's still the headline with the declination. Look, my rule of thumb is, if the government is likely to hear about it, it's way better for them to hear from you first. And so the key question, I think, that drives a lot of the analysis and the strategic judgment here is, how likely is the government to find out? There have been sort of personnel issues going on at DOJ and these priority shifts we've been talking about. I don't think that necessarily should drive or influence the decision-making too much. I mean, it bears a little on how likely the government is to find out, because if they're distracted with other priorities, or there aren't as many prosecutors or agents in working cases, it bears on that. But there are countervailing factors too, like the increase in whistleblower programs, and which makes it more likely that the government will find out. And when I was at Commerce, I actually made 2 policy changes designed to encourage more people to make self-disclosures. So they were these. First, these policies are still in place. We'll see if they last. But if you don't disclose something significant, potential significant violation that you know about, you don't disclose it to BIS, to Commerce, and they later find out about it, that gets held against you. That's an aggravating factor in determining the penalty. And then we changed another policy clarified another policy to incentivize other companies to disclose about you. In other words, we do incentivize companies to just make disclosures about their competitors, telling them that they'll get credit in the bank down the road for extraordinary cooperation if they ever get in trouble. And so we both raise the likelihood of the government finding out, because other companies may tell if you're violating the rules, and we raise the cost of not disclosing. But even with all of that, even with those 2 added things for reasons to encourage people to disclose to BIS, and it drove additional disclosures. Now that I'm a defense attorney counseling clients, look, I still think it's a very difficult decision, and disclosure sometimes the right answer, but it's many times it's not the right answer.
Leigha, what would you say about this?
I echo what Matt said. It's always going to be specific to the factors in that particular situation. In terms of when I'm thinking about risk and who is most at risk if they don't voluntarily self-disclose, this is how I would explain it to a client who is less at risk. I think if you're in one of the administration's main priority areas where they are putting additional resources into place, you are at increased risk. What are those? Well, of course, the tariff and sanctions enforcement, like Matt was over at Commerce. Also, healthcare. That's always going to be something, because so many federal dollars go to healthcare. If you're in a healthcare company and something has gone wrong and it has to do with federal money or can be traced to some sort of federal funds, I would think long and hard about whether it is important to self-disclose, because you have a lot of people, prosecutors and agents, who are dedicated to pursuing healthcare fraud. Government contractors, that's another thing, civilly, criminally. There are a lot of people who are focused on that within DOJ. And that's where we've seen a lot of self-disclosure cases. And in fact, Scott and I issued, when I was U.S. Attorney, he was First Assistant, the voluntary self-disclosure policy for our district. And some of the self-disclosures that we had were government contractors. There's a huge benefit to self-disclosure if there is anything that can come within the False Claims Act, because there will be a much lesser monetary penalty that usually comes along with that if you self-disclose, as long as there are not any other aggravating factors. If you're a publicly held company or otherwise regulated by the SEC, who has always a pretty strong whistleblower program and all of that, I would think about that. If it's something different, I think the calculus gets a little bit harder. But one of the things in terms of, the False Claims Act and government money is almost every company involves government funds. So when you're thinking of self-disclosure, it also is important to make sure you're well resourced in the compliance department in terms of knowing when you are at risk and when that voluntary self-disclosure decision needs to come into play. Because the most important thing I tell people, regardless of whether you self-disclose, you always want to be in a position where you can, because you have to do it swiftly and you have to have a lot of information you can provide DOJ if you need to self-disclose. And you're not going to have that if you don't have a strong compliance program that at some point catches this, or if you're not listening to the whistleblower who's telling you about it. I have 2 examples, and I want people to just Google this in terms of the press releases, because it's very telling in sort of the government money context of what can happen with self-disclosure or non-self-disclosure. So you have Verizon in 2023. Verizon had contracted with the federal government to provide certain internet protocol systems that would allow certain government agencies to safely access the internet without having intrusions, cyber intrusions. Well, they realized at some point that their cyber controls were not up to par. They were not what the government had required under its contract. What did Verizon do? It quickly investigated the problem. It gathered documents. It had a ton of information on it. And it reported, it self-disclosed to the federal government, and it got off really easy. It was really a brilliant move. And that is the case I point to a lot of times when I'm like, that is the way to do it. Verizon has 100,000 employees. It only had to pay $4 million in a False Claims Act settlement. It escaped criminal prosecutions. Well, it was I think it was a deferred prosecution agreement as well that was executed there, but they never formally got prosecuted. And the settlement agreement and the press release sung the praises, incredibly complimentary of everything that Verizon did in terms of the investigation that it had done, the cooperation it provided the government, and the remediation it had done. And that's the press release you want, because it really did not harm the company. So if you have an issue like that. On the other side of the coin, you have in the same year, 2023, there was, and it really was very forecasting, I think, of what we'll see in the future under this administration, a company called International Vitamins Corporation. Unlike Verizon that had 100,000 employees, this one had 1,000 employees. It imported vitamins and supplements from China for sale here in the United States. It did not accurately report how much in customs or tariffs it had to pay. It misclassified what it was importing, and it was shorting the government on paying customs. And they even had a consultant at one point come in and tell them that, like, you are misclassifying these things. They waited a whole year before even classifying them correctly after the consultant came in, and they never told the government or provided the money back to the government voluntarily that the government was owed. And so when the government did investigate this, and I believe it was pursuant to a whistleblower, they had to pay $22 million. Verizon gets off for 4, International Vitamins Corporation 22. That's an example of, what you have to fear in terms of what I think we'll see under this administration too.
Did they self-disclose? Is that what you said?
They did not. International Vitamins Corporation did not self-disclose. I believe that was a whistleblower.
You said that.
Later.
Okay.
But Verizon did self-disclose.
So, I mean, when are there different flavors of self-disclosure? Like, do you feel like sometimes someone self-discloses and it's kind of like a half-ass self-disclosure? And like, what are you kind of looking for? What do you think DOJ is looking for in that self-disclosure that might help inform our audience on like the calculus that they need to sort of like run on that decision that's not really black and white?
I'm going to throw that to Scott because he saw a lot of that in terms of under the False Claims Act. So he knows all about the points to emphasize there.
Yeah, Scott, what would you say?
Oh yeah, sorry about that. The expectations are actually pretty clearly delineated by the department in policy memos and what they're looking for. One of the most significant is the timeliness of it, right? Did you bury this for a long time after you had already learned about it to try to get your story perfectly set and your witnesses all prepared? Or did you come forward to the department? How fulsome was your production? The standard is all facts known to you at that time, right? So that you can at least tell the government what you know and things that you are continuing to investigate may proceed, but you've got to let them know what you're aware of at that time. And a big one, and one of the factors I was going to identify, is remuneration. That is your company prepared, or have they already made any victims whole, whether that be individual victims or if it's a crime against the government themselves. So there are set factors that are spelled out that the department's going to consider, every U.S. attorney's office is going to consider in whether or not a voluntary disclosure is appropriate and meets those requirements for a declination and or some type of reduced settlement under the False Claims Act. In addition to those things, you've got to factor in potential liabilities outside of the department when you're doing this analysis. So you make a disclosure to the government, but that could kick off a potential class action lawsuit that your client might have to deal with, or shareholder litigation down the road. Your D&O policy might end up being implicated, or it could throw off individual executive, criminal liability if you go disclose things and the government thinks there are individual liability. That self-disclosure only protects the company. It's not for the individual's potential liability.
Scott, let me add in one extra question here from a listener. They were wondering what percentage of companies are afraid to self-disclose because now you've opened the door to the regulators and they might decide to open the door nice and wide and come in and look and see what else is going on and do other investigations or just sort of like get out of control. I don't know if I don't need a percentage number here, but is that a real concern? Could that actually happen? We're disclosing on one thing and then suddenly regulators are asking you about B, C, D, and E as well?
Well, so I'd rather answer the percentage question because that's 100%. They're all scared of that, right? Which is understandable.
But is it a real fear?
Does it happen? It can happen. Is it something that happens a lot or often? That has not been my experience. My experience is when someone comes in and discloses, it tends to be pretty focused on what's being disclosed. They might look a little bit outside the lines just to make sure they're getting the full story from the company. But it has not been my experience where all of a sudden they start looking into everything this company's done. Unless there's some type of aggravating factors, and Matt would probably be better to talk about this, but dealing with foreign entities that they're not supposed to be dealing with, or things along those lines that really kind of one of those aggravating factors that the self-disclosure policies identify that would kick someone out. I could see that causing an expansion of the inquiry by the government and the Department of Investigators.
Okay. Well, let's take it to step 2 now. I have made my voluntary self-disclosure, and now I'm talking with the regulatory agency. We also had questions about what a good investigation and good cooperation is going to look like. And if I rush in and say, this just happened, I only know 3 facts, but now I've disclosed and I'm happy to cooperate with the investigation, like, where does that go next? And what are companies that are good on the investigation and cooperation side, what are they doing right that listeners should be keeping in mind? Matt, I'll start with you and then go to Leigha. What would you say?
Yeah, I think for when it comes to cooperation, the key is, and look, Scott just hit this a little bit in the context of the voluntary self-disclosure question, right? Cooperation, if you're in, you're all in, right? If you don't want to surface the good, the bad, and the ugly, then you shouldn't start cooperating, because I think the worst thing you can do is kind of like half cooperate, because that gets the government very frustrated, and that can be a tough philosophical sort of shift for a company that wants to sort of defend when something went wrong, wants to defend. And I think as counsel, that's a really tricky balance, and it's a really important part of our jobs, which is both to make sure that the company, that DOJ understands the company's desire, intent, and in actuality to give full cooperation, while at the same time advocating forcefully for the company as to why what they did deserves some discretion and mercy from the Department of Justice because of all these factors. But I think for cooperation, it's not. We used to say this when I was on the government side. I understand it well on the defense side. Cooperation is not just responding to subpoenas, right? That's not cooperation. It's got to be like proactive. It's got to be sort of interviewing, doing a real internal investigation and highlighting documents that are not helpful to your cause. You got to not only give them to the government, but highlight them for the government. It can be a real cognitive dissonance, because that's normally not right how you feel like you're protecting the company. But when you're in a cooperation posture, the worst thing you can do is to try to bury something or minimize something, because that'll come out eventually, and then you lose all credibility with the government. While at the same time, you can't be a pushover, and you have to be able to argue why the facts are not as bad as the government thinks. So in other words, my overall philosophy, I think people's overall philosophy on the defense side is, don't fight the facts, right? The facts are the facts. You got to surface the facts and convey the facts to the government clearly and directly. But then, reasonable people can disagree on what the consequences of those facts are and what any sanction for those facts should be. And that's where you can really be a skilled and forceful advocate for your client.
But I think you said something important there. You said a lot important, but you said a cooperation posture is key. And I think if we go into, if somebody is in that kind of a conversation and it feels adversarial, like we're on different sides of the table, well, the outcome may be very different than if it feels like it's truly collaborative and you're really trying to, solve the problem. I mean, there's some level of subjectivity, I'd imagine, in whoever from the government is assessing these facts and that kind of posture or that level of cooperation. And, it seems like time and again, it's kind of contingent on if we're giving a good faith effort to extinguishing this problem or if we're keeping those cards close to the chest. Those can lead to very different outcomes, I'd imagine.
That's kind of where I want to go with another question there, is that how the companies, is there a tension between compliance people who might want to demonstrate we have a culture of compliance, we're very ethical, we cannot tell a lie, even if it's unflattering, versus maybe outside counsel and legal team who are saying, let's keep our liability to the minimum required by law, and then we stop. I don't know, do those tensions come up? Do you see them? Leigha, what would you say to that? Like how companies try and navigate that kind of discussion?
Yeah, I think that the C-suite is probably inclined to hire an aggressive firm at the outset, and the compliance, the compliance officer probably is advocating for the opposite because they probably understand the issue a little bit better or are kind of more familiar with the process. And Scott and I were actually talking about this yesterday when we were preparing for this. And he said a phrase that I'm just going to steal, but attribute to him, which is the time to be aggressive is in the courtroom. It's not when you're talking to the DOJ at the outset, because prosecutors and agents are people too. And if they hate you, they're not going to want to let you get off easy. And so you can't have people being super aggressive and just, you can't be stonewalling the investigators and the prosecutors at the outset. You need to go in and be cooperative and be prepared to disclose, the bad facts too, like Matt said, and get them on your side. You want them to be your advocate when they're negotiating with their internal group about how easy to let you get off, because they have such a range of penalties, monetary and otherwise, and you want to be on the lower end. And that's where I go back to that Verizon case. That's what Verizon did. That's why they got out easy. If you stonewall, which, in some cases where I think there are a few cases where it seems like I would probably always advise people to self-disclose, and some that I would say don't. And on the ones that I would advise to self-disclose, I just think that, that is the start of a good relationship and getting off really easy, instead of, this kind of bad relationship that's going to be created if you, are withholding stuff, then they find out about it through a whistleblower. And, it goes from there. And if you're self-disclosing, you've just got to be in that cooperative mindset.
I mean, perhaps the most important thing you just said is that they are people too, which means that they're open for influence, and they are going to be trying to feel out how engaged are you? Are you kind of playing a game here? Are you, is this a half-baked disclosure, or are you truly kind of all in trying to fix this problem? And so there's a lot of opportunity. And, again, to Matt's point, in the posture that we show up in that, or the posture we show up with in those conversations.
Scott, I don't know if you have any other thoughts you want to add here. I know Leigha stole one of your phrases. If you want to steal one of hers back, feel free.
Grab one back. Balance this out, Matt.
I appreciate that. That happens all the time to me. I'm used to it now. No, I would actually dovetail off something they both said, and I'll address the phrase that she also used. I don't want folks to get the idea that you should not be assertive in your discussions with the department. Right? You can absolutely be assertive. I don't think aggressive is effective, right? And I think there's a big difference in how counsel interacts in being assertive versus aggressive. You can certainly defend your positions and defend your actions, and that can be extremely beneficial. I would also say that I believe the biggest mistake that folks make is something Matt talked about, and that is trying to bury facts or bury witnesses, right? So I think the most important thing compliance can do is help work with counsel, whether it's internal or external, and get ahead of the investigation as fast as you can. You want to know what these witnesses are going to say. You want to know what these documents say. so that you can help define and craft and define the narrative that the company is going to present when they're dealing with department officials. And I think if you do that, that can be very effective, especially in those conference rooms before you ever end up in a courtroom.
Okay.
Can I piggyback just really quick on that too? What I want to say is this is actually in a broader, not just like a self-disclosure, but if a company finds out that there's wrongdoing and they want to report it, not because they feel like they are themselves liable, but because they have found a wrongdoer within it. That is part of controlling the narrative. Ideally, and this is how, I think we'd all look at this in terms of how we would try and portray it to the DOJ is if there is a wrongdoer and it's not clearly some sort of pervasive thing that's happening in the company, or it's not something that's overtly meant to benefit the company, we want to come in and portray the company as like a victim. And there's a wrongdoer in it, but it's not because of the company that they're doing this, and it's not encouraged by the company, and try to separate. So even sort of if you're not self-disclosing officially under the DOJ guidelines or a whistleblower, or not whistleblower, but a self-disclosure program, then you want to come in with that mindset, which means you have a good narrative of what happened, that whatever it is, it makes the company itself seem less culpable or not culpable.
Yeah, you don't want to be like that guy in Casablanca who's like, oh my gosh, there's gambling here. You know what I mean?
Exactly.
But let me pull on that thread a little bit more. How important is it to help the government find the individual wrongdoers? Somebody somewhere did the act. And the Justice Department has talked for many years about the importance of going after individual wrongdoers. This administration now in the last 6 months seems to have turned the volume up on that point quite a bit, that's what they're looking to do, is to hold the individuals accountable. So how much more important is that? Or how much do we need to make that a priority as opposed to, I don't want to say coughing up a sacrificial lamb or a scapegoat, although the cynic in me wonders how much that might also happen. But how should we be thinking about how important that is to find the individual wrongdoers and get that out there? Matt Axelrod, I'll put it to you first, and then Scott and Leigha.
Yeah, look, I think it's really important for a number of reasons. As you said, I think actually, when I was working for Deputy Attorney General Sally Yates, she, I think, really kicked off the push for individual accountability. The theory being, when companies violate the law because of actions of individual employees, right? That's the vicarious liability of the company. What was happening was DOJ was doing a lot of big dollar resolutions with companies, but no individuals were being held accountable. And the concern was, from the Department of Justice's point of view, that it was just the cost of doing business. And at the same time, that it's right when you find and I think this is the current administration's view from their policy pronouncements, when you fine a company, you can't put a company in jail, but when you fine a company, you're affecting a lot of innocent parties, right? Shareholders who had nothing to do with the crime, employees who had nothing to do with the crime, like people who have retired from the company, may have a pension plan, right? Like all those people are innocent, yet are being punished sort of derivatively or vicariously because of the actions of an employee or two or three. And that, why Scott and Leigha are saying is you want to, as defense counsel, let the government know that, hey, this isn't the company that did this. This is a rogue employee that did this, and make that argument. But I do think we're seeing a shift philosophically at the department from over time, where when Deputy Attorney General Yates really said, hey, we've been too much at the department just focusing on the companies. We have to focus on individuals, because the individuals are the ones actually doing the conduct and will respond to incentives and don't want to go to be convicted of crimes or go to jail. And so if we focus on them, we can deter bad conduct from happening in the first place. So don't just go after the company, go after the company and the individual. And now I think the pendulum is swinging. So the department is saying, at least in a number of circumstances, they're going to go after just the individual. So we were at one end of the spectrum, just the company, not enough focus on the individual. Then for a while it was both. And now we're moving to, I think, an era maybe in when the individual investigations and prosecutions are a higher priority than going after the company itself.
So Scott and then Leigha, give me your thoughts there too. But again, I'm going to play my cynic card that if the individual is a senior person like the CFO or the CEO, and they're also the ones wondering, well, do I self-disclose or not? If you're the guy, that's a wonderful argument to not self-disclose. I could see this, being a very difficult issue to try and hold people accountable. But Scott and then Leigha, what would you say about how to think this through?
I think it's a very fair point that if ultimately the decision maker is the one who's committed the conduct, it's going to be very difficult to convince them to self-disclose anything, right? Mm-hmm. The risk, there is a risk analysis that even that person is going to have to do, and that is, do others in the company know, so that in fact a whistleblower or someone who just calls in an anonymous complaint to a hotline is going to disclose that for you. So you're going to remove any of that potential benefit that you're going to get from the outset. So it's going to be a risk tolerance question for that person if they're that high up in the chain. But I think their co-executives are also going to have a lot of pressure on their decision making, because if it's someone high up the chain, let's say a board member or someone like that, or someone in the C-suite and others know it, well, they've got a fiduciary duty to the company and to the shareholders, right? And so if they fail to disclose that, having known that it was occurring, they're now putting the interests of the individual ahead of their fiduciary duty to the company and to shareholders ultimately, and creating personal risk for themselves. Maybe not criminal at that point, but certainly financial risks. So I think there's going to be a lot of consternation amongst those folks to just sit on it. So I think the more likely scenario, and what we've seen in the past, is try to push them out the door quietly, right, and hope that it never comes to light. That's if it's someone that really in those positions where they're the ultimate decision makers.
Yeah, I'll piggyback on that and say, two cases come to mind. We have done in our district, because it is such a major district in the United States, Dallas-Fort Worth. We have so many companies here that we've prosecuted a lot of individuals who have been in those companies, and I think what you don't want, so I can think of one where it was one who was really controlling the company, and he was the only one prosecuted out of that. It was really, he was doing stuff that it was such a giant amount of money that he took, and they tend to spend it on crazy stuff. Like I remember I worked on one case where a guy bought like a military tank, and he bought like 35 cars, and he had a 5-story house, and like they just go crazy. And so that's one example. Then another example, so clearly, yes, he would not have voluntarily disclosed, and he really was the company. And then there was another one where we prosecuted 4 executives of a company. One of them should not have gone along with it, right? Because now they all had to serve time in federal prison for it. And they fought really hard, and they had a lot of money, but it went up to the Supreme Court, and they denied cert, and they had to serve their time in jail. And so you have to, as an executive, have the courage to do the right thing, even when your co-executives are not doing the right thing, because you are at risk, not just civilly, but criminally. You can go to prison for going along with some of the types of conduct that we've seen. And so it's really scary, and you have to do the right thing. But also you have the board of directors of companies. I mean, there should be someone, hopefully, ideally in a company who, someone in a lower level position can report to, and there can at least be a conversation amongst some people about whether to go to the authorities with it. But I think in that case, yes, for your own personal protection, you have to think about that. Not even just the interest of the company, but your own personal protection in terms of your future. You cannot go along or let some really bad conduct slide.
Okay. So we have about 30 minutes left. I want to shift to a couple of different subjects within that time frame. One of them is going to go back to you, Matt Axelrod, because I did want to ask a bit more about export control and sanctions compliance. And one question I had was, for this audience, who probably for the last 15 years have had a steady diet of FCPA compliance and all of the apparatus for that, how much can that knowledge and how much can those policies, controls, like, can they be transplanted over to sanctions compliance? Like, if you've been doing due diligence around anti-corruption for third parties, how much of that can easily be transfigured to due diligence on customers or sanctions compliance issues like that? I'll stop there, but how much can what they already know be shifted over to something like export control issues?
Yeah, it's a good question, and there are some similarities, as you suggest. Managing international risk, all of these, right? FCPA, sanctions, export controls, so they're all by definition extraterritorial, international, and managing international risk can be tricky. Jurisdictions that are high risk for corruption can sometimes also be high risk for sanctions or export control violations if they're not strong rule of law countries, although I do think the overall heat maps for where these areas are the greatest risk don't fully align, because there are actually some significant differences. For folks who know the FCPA well, they're often focused on politically exposed persons and third-party consultants, whereas like for export controls, you're more often focused on specific items, specific products of the company, and specific end users of those products abroad. Instead of third-party consultants being the highest risk factor, it's often distributors, right? You know who you're selling to, but then you don't know who they're selling to and they're selling to, and the export controls follow the item, and you're responsible if the item ends up even down the chain somewhere where it's not supposed to.
Right.
I'd say another difference, it's the level of regulatory complexity. Folks may disagree, but I think the FCPA is pretty straightforward. Like, don't pay bribes, right? Like pretty either nuances, but the top level is pretty simple. Export controls and sanctions are different. They have like really highly complex regulatory structures. And so I think you need to have specific subject matter experts on trade compliance to advise both in-house and when appropriate as outside counsel, because you need like specific screening procedures, which I think is different than the FCPA. You have to run proposed transactions against lists of prohibited parties so that you don't risk sanctions or export violations. And that takes some infrastructure, and I don't think there's an easy analog in FCPA work. So, look, overall, given the international angle, I think it can sometimes make sense to combine your FCPA compliance team and your sanctions export control compliance team in a single department. I think a number of companies do that, but also there are definitely different areas of subject matter expertise, and I think you need sort of some specialized, trade folks to help manage your sanctions and export risk.
All right. Leigha and Scott, do you have any export control advice you want to chime in on before I go on to? I got some other issues for you too as well.
I don't, other than just saying it also, I think it was a False Claims Act priority, and Scott can speak to that. So even in terms of, it's just perennially we're going to see these issues, but they're very much ramped up. And we were just at an automotive conference for our firm. Our firm actually does work for a lot of awesome companies, but they're very heavily into the automotive industry. And this was a huge topic at the automotive conference that our firm just held in Detroit yesterday, where they talked about all of this. And so it affects so many people. And, obviously, yes, there's a government enforcement angle as well as a business angle to that, and they cannot ignore the government enforcement angle.
And now, Scott, I have a False Claims Act question, more, I guess, suited for you. I am curious how a standard FCPA issue, even if there is such a thing, like how does this often happen? Because I know that you could have a whistleblower file a key tam lawsuit. Does it mostly happen there? All of these lawsuits seem to last for like 68 years before the Justice Department finally swoops in, and then they settle within another 2 or 3 years. Like, what's the timeline for False Claims Act enforcement? And might that change if this department now seems to want to use the False Claims Act for everything? Are they going to come in more quickly? Are they going to bring their own? Or is it still going to be a majority or key tam whistleblowers? Like, what do you think will happen there that compliance officers should know about?
So they come about in a couple of different ways. The largest, I think, over the last several years has been the key tam work, or key tam cases. I think there were 979 last year is what the department's reported. However, we do get a number, I should say, they do get a number of large actions that are that come up through agencies, through data analysis, things along those lines that, flags an auditor to say something seems off here. They'll let an IG know. The IG will assign an agent, and the next thing you know, that agent's digging into it, and it could result in a False Claims Act case. There's also just anonymous hotlines that most agencies have, that someone who doesn't want to be an official whistleblower or a key tam relator, they can call that in, and that has spurred a key tam actions. And then last, and not often, but press, they're people. Nick mentioned earlier, they're people too, and prosecutors and agents read the newspaper, they see the headlines, things along those lines, and if something smells off with a certain story or certain events that might involve government dollars or avoidance of responsibilities to the government, that could also, cause someone to, get an interest and maybe think about looking into it further. So it can come about in a number of different ways. In terms of
is it fair to say that these lawsuits are often long and tortured, and they seem to go on forever?
So that's going to vary district by district. So and a lot of that is tied to the judges and how long judges will allow investigations to go on. So in some districts, the judges have really tightened up the amount of time the department is permitted to investigate while the case remains under seal. Some as little as a year. Some allow the 3 to 5 years, like you're talking about, 3, 5, 6 years for the department to investigate and make a decision on whether they're going to intervene and take over the case. And it's then and only then that the lawsuit acts like traditional litigation that we all know. So yes, they can be long and tortured. If you're specifically if you're in a district that allows, the judges have a high tolerance for extensions of the seal, is what they're referred to in the department. If they have a high tolerance to allow these investigations to go on for an extended length of time, then yes, they can go on for years and years and years. But I think a lot of folks think that it is always the investigation and it's the government's responsibility that drags things out, so to speak. But there are many times when the government will make an intervention decision in a reasonable amount of time, reasonable by investigation standards, but it's just civil litigation is often so protracted. And so it can add on to a great deal of time to what was originally thought to be an investigation that should be over fairly soon and feels like it's gone on for 5 years.
And then, Leigha, here's a question that I think is probably suited to a former U.S. attorney. Somebody was asking, to what extent does the prosecutor's, individual philosophy influence the outcome of the case? And what is the tug of war between what the particular district wants to do versus what Main Justice has said, here's our policy? I don't know how much flexibility or stretch and give there is between those two poles, but can you just tell us a bit about how does that factor into investigations and case resolutions?
Yeah, actually, this is really a good entree for me to explain something that I've kind of been evangelizing since I left the department, because one of the things I like to do is educate people on sort of how the department is structured, because I think that factors into both an individual's sort of way of handling things, but also more broadly how they answer to the top administration at DOJ. And so what a U.S. Attorney's Office is, because I always kind of like to start with it. So there are 94 U.S. Attorney's Offices in the United States. Basically, those are the people who do the day in and day out work of the Department of Justice across the United States. Texas, for example, has 4 United States Attorney's Offices. We were over the Northern District of Texas, which I said covers Dallas and Fort Worth, also everything over to New Mexico and up the entire Panhandle. And so we covered all federal prosecutions and all civil litigation that involved the federal government for that entire territory. What that means is if you have, if you are a company who is based in Texas, or you see that there's a problem in one of your facilities that's in Texas, or if there's something that relates to, that area, then that U.S. Attorney's Office is going to be involved in that case. Sometimes it'll be a case that's sent to them from what we call main justice. And, Matt worked a lot in the very high up levels at main justice. And so there is some communication there. And then sometimes it is a case that basically is exclusively worked by that district with very little to no input from main justice. And that means that individual prosecutor and their supervisor have a giant amount of discretion. The garden variety fraud case that's prosecuted, or even FCA case that's investigated, is handled almost exclusively on the local level. There might be some communication with DC, but it's really going to be something where the thought process on how to handle it is going to be more local. And it's going to be something that actually transcends the priorities of the administration. There's a certain amount of bread and butter fraud work that's done in every district across the country that really does not entirely track the priorities. Like I said, like embezzlement is something that's low-hanging fruit. If you get someone from inside the company to report someone who's embezzled something, or they figure that out in some way. And that's an easy thing where you can get DOJ, like any other organization, loves a good headline. So if you can kind of take an easy win like that, no fraud case is easy, but someone on the inside, that's why they love whistleblowers. That's why the government is only expanding whistleblower programs, because in any type of criminal case, if you have someone on the inside, whether it's a drug cartel or a company where there's wrongdoing, you want an insider, because that's the easiest way to make your case. So you have these people, these prosecutors who are working on these cases, and you have agencies that are staffed, some of them entirely with people who work fraud cases. You have IRS criminal investigation, Small Business Administration, OIG. There are so many federal agencies that you don't even think about. A lot of people just think of FBI, DEA, ATF, sort of like the big three. Secret Service has a giant presence in sort of cryptocurrency and other things happening in the cybersphere that connect to money. And so that is stuff that's happening, doesn't necessarily track priorities, and the individual prosecutorial discretion is huge. That's where you want to have people who are familiar with that district, or if they're working with main justice, familiar with that prosecutor and main justice, who understand how that section works, how those specific prosecutors are likely to handle a case, and be able to approach them with that familiarity, because you don't want to come in guns blazing if that's going to totally turn off the prosecutor and, like I said, cause them to hate you. And you kind of want them to kind of be on the more lenient side. But there are prosecutors who tend to go, kind of like harder on some people and some that don't. And, so that's a lot of it's luck on the draw as to who gets the case, but a lot of it is sort of how you handle it based on the counsel you hire.
Interesting.
Yeah, I could piggyback on that, Matt. I agree with Leigha. Individual prosecutors matter a lot at their early stages. They have close to total control, as Leigha said, their discretion over how an investigation is conducted. And you, as defense counsel, can't really go running to their supervisor to complain, every time there's a particular document request or line of questioning in an interview you don't like. And there are exceptions, of course, if a prosecutor is abusive or wildly unreasonable over and over, then you can try to escalate it. But for the most part, their supervisory chain, right, the Scotts and Leahs of the world are going to defer to their line person's judgment. Line prosecutors have a lot of independence. So the best bet for you to get a good outcome is to convince the line prosecutor that you deserve one under the DOJ policies. DOJ has very specific factors that prosecutors are instructed to consider in corporate cases, and you can and should make arguments for an appropriate resolution based on those factors. But when it does come time, like at the end, for the charging decision or resolution, I do think the dynamic of the line prosecutor being pretty much an independent actor, it changes a bit. And in corporate cases, particularly big corporate cases, right, those decision points, not do I subpoena particular items or ask particular questions, but what is am I going to charge them? Or if we're going to have a resolution, what's the fine going to be? Those have heavy supervisory involvement. In fact, for resolutions over a certain amount, I always forget whether it's $200 million or $250 million under the Justice Manual policy, it actually notification has to go all the way up, almost all the way up in the department to the Deputy Attorney General's office where I used to work. And so, and even if it's not that amount, it's still going to go to the boss, right? There's no way that someone in Leigha or Scott's office is going to resolve a case for even $1 million that doesn't have Leigha or Scott signing off on it. So as defense counsel, if you've been unable to convince a line prosecutor of your arguments. Again, so that's the best, because the bosses, their instinct, which is rebuttable, but their instinct is going to be to back their people. For best way is to convince the line prosecutor your arguments. But if you can't, there will come time, and there should come time, and you can, with experienced defense counsel, make sure that you are able to make those arguments to someone up the supervisory chain at the appropriate point in time.
So, speaking of trying to convince the powers that be for a favorable resolution, the last thing that I wanted to cover in this keynote was the compliance program that our listeners are generally going to be responsible for building and making sure it's running well and presenting it and showing it off to prosecutors possibly. I guess my first question, I'll throw it out to anybody who wants to take a stab at it, is do you think we will see changes to the guidelines for the effectiveness of corporate compliance programs? I'll stop there. Do you think that we're going to see that? Like the record show, nobody's taking the bait.
I think that's very difficult, because the analysis of the effectiveness of something is very subjective.
Right.
And when the department puts out guidelines and policies, they try to do so in a way that's actually, somewhat measurable by the prosecutors, because otherwise you end up with things being applied in unfair ways across the country, right? So you want to try to have consistency across offices and across the country in terms of how you are measuring something. So how to measure the effectiveness of a compliance program is to me, that's very difficult. Is there one present? Was it effective in this situation? Did they take corrective actions? All of those things, of course, are going to be in place. But whether or not, I think you've got to be able to measure something to attach accountability to it.
Okay.
Yeah.
We have a whole lot of listeners saying no, we're not. They don't think we're going to see big changes to the effectiveness guidelines.
Yeah,
I'm sorry.
I agree. I'm not sure we're going to see big changes. I wouldn't be shocked if we see an update. That's just, I think, standard from time to time that gets. But I think the three core parts of and so I assume folks are aware, but the criminal division of DOJ has published guidance. I think this is what you're referring to, that outlines its compliance expectations and the framework that it uses to evaluate corporate compliance programs. Interesting. I could be wrong on this. Maybe Leigha and Scott will correct me. I actually think that just is that guidance from the criminal division is just binding sort of on the criminal division and their cases. Scott and Leigha worked in a U.S. attorney's office. A lot of cases are brought by U.S. attorney's offices as another sort of DOJ structural thing. The criminal division actually is not the boss of the U.S. attorney's offices, even on criminal matters. Only the deputy attorney general is the boss of both the criminal division and the U.S. attorney's offices. So criminal division policy and guidance actually doesn't bind the U.S. attorneys. But anyway, the criminal division guidance on compliance expectations, it has three central questions. Is the program well designed? Is it adequately resourced and empowered to function effectively? And does it work in practice? And then there are all these subsidiary, I think over 100 questions that prosecutors are supposed to ask to interrogate whether the compliance program was up to snuff and try to evaluate it. And so it's already been revised once. Those three principles got tweaked a little bit. They're not entirely different or that different from before, but they got tweaked a little. I wouldn't be surprised if they got tweaked again. I wouldn't be surprised if the questions sort of evolved and changed a little bit, but I don't think given all the thought and time that's gone into that document, and given that things haven't changed that radically in compliance world, I wouldn't expect to see big changes there. But we'll see. It's a new DOJ, and so I think time will tell.
I mean, at some level, the way that like a doctor is going to like assess if somebody is healthy has probably not changed that much, kind of to your point, over the last 100 years. Maybe there's different tests, maybe there's different technology to kind of assess it. But I think like a corporate compliance program is kind of akin to like personal health. There's different indications if somebody is healthy or not. And I think those three criteria or those three kind of underlying principles we can use as, high agency actors within our own organization to kind of assess where we're at. Effectiveness, to Scott's point, is sort of this like elusive thing, kind of akin to like perfection or something that you can continue to strive toward. And in certain situations, maybe the controls you have in place are working. In other areas of the business, maybe they're not. So there's always room for improvement. But what are they going to do? Come up with, 10 new criteria that nobody can think of? It's going to be kind of the same thing.
Leigha, what were you going to say?
No, I totally agree. Like, I absolutely agree with what Nick and Matt and Scott have said. I can't really imagine they'll make I would think that they should not. If I were in charge there, I would say we are not. This is really solid. This is very well thought out. I think the only thing we've seen is like a change to what happens if you are not following the principles in terms of penalties. So we know that monitorships are going to be a lot more limited. If they do the evaluation, it's likely not going to result in a monitorship, but it could result in not, for example, accepting a voluntary self-disclosure resulting in a declination. It could constitute an aggravating circumstance if you're not following those principles and you have basically just a paper-only compliance program that hasn't really prevented anything really seriously bad from happening. And so I think they're going to be using it, but it's kind of like, why would they? They certainly, I think, have no incentive to lessen it because it's not really attached to a certain penalty right now. It's more, it's kind of can be used in different ways. And so they might decide not to use it for a certain penalty and to use it more for others, right? It's in the actual sentencing guidelines too about, they evaluate the effectiveness of compliance programs when they're looking at how much of a monetary penalty to put on. That, they could always, the Sentencing Commission could change that. But it's kind of a freestanding document and structure that I think only positively incentivizes companies to run cleanly. So I think they will and they should keep it.
Well, yeah, and I think if you think about it from their perspective, they're trying to build some principles out that can apply across all these different businesses and all these different sizes and all these different industries. The more specific it gets, I think, the more like fragile it gets or something.
So
Absolutely.
One other question that we've had, I'll string a couple of different questions together, but I think there are a lot of compliance officers who are curious about how prosecutors will evaluate the effectiveness of the compliance program, which is not necessarily the same as here's all the stuff I'm doing, because that just means you're busy, but you might not be effective. So I don't know, like what sort of key performance indicators are there, or how subjective would this actually be? But how would you try to really deeply understand that, yes, this compliance program gets it and they work, not they're running around like chickens with their heads cut off? I don't know, Matt, I'll pick you at random here. I don't know what thoughts or advice you'd have, and then I'll go down the line.
Yeah, look, the good news is it's an open book exam. And like by that, I mean that guidance that I mentioned earlier, and it's on the criminal division website, and it's public. Everyone can see it and should see it if you're working in compliance, right? Because it doesn't just outline those three top level principles we mentioned. There, as I said, there are, I think, over 100 subsidiary questions, and so on for effectiveness. There are, I don't forget how many, 20 to 30 sort of questions, sub questions that are exactly what the department, at least the criminal division, will use to evaluate whether a compliance program has been effective or not. And so my advice is to look at that and take the exam. Take it now. Don't wait until you're sitting in a conference room with the government, because if you take it now, the questions that prosecutors are going to be asking, you can see how you measure up. And if there's an area where you fall short, that way better to remedy that now. As I said earlier in the program, that'll help you. You ever have to explain it to DOJ prosecutor, but B, it'll help reduce the chances you ever get in front of a prosecutor in the first place. Because remember, if you are being graded on your open book exam of how your compliance program is stacking up, if you're sitting there in front of a DOJ prosecutor, something's gone sideways, right? Despite
Yep.
your best efforts, like something has happened. So you're playing a little bit from behind, trying to convince DOJ, a skeptical prosecutor, that despite your best efforts, despite a risk-based, well-implemented compliance program, something still happened. And so I really do think you want to measure against what you know the sort of the questions are going to be ahead of time and see how you fare. I don't remember what they all are, but they're there and you can go see them.
So Leigha and then Scott, give me your thoughts as well. But I know, for example, a lot of listeners will be thinking about, okay, I guess I show them my training completion rates, or I show them how my policy changes tie to more whistleblower reports, or they've got all sorts of calculus and equations that they're trying to do in their heads to say, therefore, the result is effective. Is that how it actually works when you're looking at compliance programs or trying to figure out how effective it is? What would you say, Leigha, first?
I think this is going to sound unfair on the department's part, but I just think this is kind of the way it is. There's a lot of Monday morning quarterbacking that would be going on. And the proof is kind of in the pudding in terms of how quickly are you reporting, and how much do you know about what happened, and kind of and then they look at what were the controls that were not in place, or were they in place but it happened anyway. So I think part of the difficult part of being a compliance officer is you don't know where the fire is going to start. And there's, where do you focus your compliance program? There are great principles out there, but I think what the prosecutor would be looking at is in terms of that specific issue that happened, and what were the controls, and how did the compliance program function when it came to that department or that type of employee or that type of problem that was created. And that just makes it really hard because you can't always anticipate it. That's where the risk assessment comes in, of where do we put our resources, and where do we strengthen our compliance program in terms of what is most likely to go wrong, and put our resources there and put our training there.
Scott, what would you say? And then Nick, I'm sure you have something that you'd want to add here about what effectiveness looks like, how you figure it out and present it. But Scott, you first.
I don't have much more to add. I think one of the things, though, that is significant to me, or always was when I was in the department, was the follow-up when vulnerabilities were identified in compliance programs. So you have the training, where those shortcomings are, and did you in fact follow up and circle back to address those? That, to me, I think it's very easy to say, well, we have the training module and we tell everybody to do it. But then there was the lack of follow through, or the lack of circling back and kind of closing that loop to ensure that it was happening, was one of those areas that I saw repeatedly that became an issue.
Sure. Nick, give me something here. Compliance programs.
I think it's kind of like pornography. You know it when you see it. You know what I mean? Like when I was in accounting and we were doing, audits and stuff like that, you're coming in and you're trying to see, do the financial controls work? And so you're pushing on things, and based on the responses from the CFO that you're dealing with, you can kind of get a sense on, if the materiality threshold is being sort of monitored, and if the controls are flexing as new risks sort of come into place. I think like our best defense is always a good faith effort. Like, nothing is ever going to be perfect. You can't like sort of objectively prove effectiveness, perhaps only in like the absence of like something going wrong. But even in that case, it could just be that something hasn't gone wrong yet. So, this has been sort of stated a couple of times throughout this conversation. And I think Andrew McBride has a great way of talking about it. He was at Albemarle. He won a massive award last year for Program of the Year in the way that he helped his organization navigate through their DPA. And as he talked about it, he wasn't so much as trying to like prove his effectiveness. It seemed like he was really trying to, as Matt said, really collaborate with those outside prosecutors and show them how he was thinking about it and what changes he was making based on the new risks he was seeing, and how he was sort of going down the list of, risks within the organization. As Scott said, it's a very sort of subjective thing. Is it effective or not? I mean, who knows if it's effective or not? You can only, I think, make it more effective, or you can only sort of point to the things that you're doing in your pursuit of that effectiveness, which again is like perfection. It's not attainable, but there's things you can point to as you build your case or as you build your argument on steps you're taking to drive that effectiveness forward.
Scott, just to build on one point that you had said about holding people accountable and how important that is one piece of evidence. I do remember I once asked this question to a chief internal auditor at one of the largest banks in the country, and he flipped it around. He says, no, what are the symptoms of an ineffective compliance program? And the very first one he said was unaddressed audit findings, because now you have a problem and senior management is not doing anything. And that tells me the culture is wrong. And then suddenly we're on a slippery slope to nowhere's good. Yeah. And that answer stuck with me for a long time. We only have about 5 more minutes here. So I did want to sneak in 1 or 2 more sort of prosaic questions from readers. Scott, I'll put this one to you because this is related to the False Claims Act. But somebody is writing about, is it possible we will see these challenges to the constitutionality of qui tam lawsuits? And I know there was already one ruling in Florida that qui tam lawsuits are not legal. And there's, I think, another corporation that's trying to challenge it. Like, Scott, I don't know how much you have that on your radar, but if you do, is that going to be a thing? Are these arguments going to have legs and go anywhere, do you think, or challenge how the FCA works?
I think it is very much on my radar. I think it's a big thing. I think ultimately it's going to end up at the Supreme Court, and they're going to have to decide. And the question is whether or not a relator, right, or a qui tam relator can proceed on behalf of the government. And the government has argued passionately that yes, and under both administrations, under the recent Trump administration as well, they are arguing that yes, this is constitutional. Yes, it should be allowed to remain in place just as it is. But I think yet it is to also one more yes, it's going to be challenged across the country. I think in a number of actions, and ultimately the Supreme Court's going to have to address the question.
Okay. And then last question is a bit of a hardball one here from people, but I'll just ask it. We've talked an awful lot about prosecutors evaluating compliance programs and giving thoughtful analysis of it. Do they have the personnel to do this? Because there have been layoffs at DOJ. They're tied up in immigration cases and various other fights over sanctuary cities or other policy issues. And so to what extent is the department's, are they fully equipped anymore to still be able to bring the same level of expertise and scrutiny to these cases that we've seen in the past? I don't know if anybody wants to take a swing at that, but that's the question.
Sure.
I'll go ahead.
Go ahead,
Matt,
Leigha.
you go. I have some thoughts too.
Yeah.
No, go ahead, Leigha.
No, Matt. All I was going to say is, from now, it's like if I say something wrong, I'm going to feel stupid.
I know. Spotlight's on you, Leigha.
Like, always good to just go second. I shouldn't have jumped in there. So the 2 top people in the DOJ fraud section are career people who I worked with when I was U.S. attorney. And so I think that's part of what we're seeing in terms of the restarting of some of the FCPA cases. And some of the things I've been saying are like, yeah, I kind of thought it would get back to, kind of what it was in terms of the priorities and what they're doing. I think they are doing things. I think, like I said, at the U.S. Attorney's Office, they're doing things. They still have a lot of fraud cases in our U.S. Attorney's Office. There is more limited staffing right now. I think that is a problem across the entire DOJ because of all of the, we call it the fork, like when we're like asking people, did you take the fork in the road email?
Yep.
A lot of people took the fork. A lot of people have just moved on to do other things without even taking the fork. And so there's a dip in prosecutors' numbers right now, but those cases are still being worked. It's not like they've just closed the cases. So they're doing it. Things are probably happening slower right now, but I think that is temporary, and I think they will be restaffing. A lot of U.S. attorneys' offices are actively hiring right now, and Maine justices too.
Okay.
Matt,
any other 60 seconds or so?
Well, I would just say, look, I think so. The fraud section, right? The FCPA unit does a lot of the corporate cases that the department does each year, and they've slimmed down considerably. They're no longer 40 prosecutors there; it's down to just under 20. But frankly, that's what the size was probably 6-7 years ago, and they were doing lots of cases. And so I do think there is a tension between a loss of institutional knowledge, but at least at main justice in the fraud section, there are so many sort of experienced prosecutors there that I think, yes, there are still people to do the work and who know how to apply the principles and all that. I think in U.S. attorneys' offices, depending on the size of the U.S. attorney's office, there generally aren't quite as many prosecutors that are in economic crime sections as are in the fraud section at main justice, and there might not be many that do big corporate cases. And so if you have two and they both leave, then you have a real brain drain and a gap for a little bit of time. But I don't think anyone who is I don't think anyone can sort of take solace in the fact that, oh, well, there are folks, there's no one minding the store. There are definitely people minding the store. The cases are going to continue to come. Yeah.
Okay. Well, that is the end of our webinar here. This has been a fascinating discussion. We covered 2 tons of ground. Nick, I'll let you wrap it up and take it home for us again.
Yeah, let's get a massive emoji explosion. This was phenomenal. I feel so much smarter. Thank you guys so much for joining us. Matt, Scott, Leigha, of course, Matt, you are the master moderator. This has been a great day of learning. We're up to almost 36,000 emojis. You guys are making my day. One thing I wanted to say about an effective program is I think taking a little scientific approach, like a scientific method, thinking to your program might be a good hack. So if you come up with a hypothesis, the scientific method entails nullifying that, nullifying or, you're trying to nullify the null hypothesis. Sorry. Long day for me. So like if you're asking, oh, is my program effective? Well, then try to prove that it's ineffective. And I think if you can kind of flip that upside down, you might be able to see some gaps that your current vantage point is maybe, not showing you. So thank you guys so much. 4:15 on the dot. We are starting the next session, becoming it's falsify the null hypothesis. There we go. It is in there somewhere. We are going to be talking about becoming the office of Unlock with the one and only Dr. Hemalomax. So 4:15 it is. Take a break, get a coffee, go to the bathroom, whatever, and we'll see you back here in a few minutes. Thank you all. See you in a few. Thanks a lot.
Thank you.